to make a finding of contempt and to put my client in jail.
All right. The court grants the motion for judgment on violation number 5. The court still finds her in contempt on violation number 2. Just so we're clear, there is nothing that requires father to do anything additionally beyond him showing up. It does not require him to give mother a second phone call. It does not require him to make a police report.
Today's case opens with Father Rene Velasquez enforcing a December 2023 last custody order against Marlene Ramirez. Joint conservatorship, Thursdays guaranteed. Texts sent, exchanges disputed. Screenshots will matter, timing will matter, and consequences. Loom. Stay sharp, subscribe, like, and share. For more dramatic courtroom breakdowns as emotions rise and stakes escalate fast.
Attorney Garza, you may call your first witness.
I call Petitioner Rene Velasquez.
Okay.
Mr. Velasquez, could you please state your full name for the court, please?
My name is Rene Antonio Velasquez Orellana.
Mr. Velasquez, how many children do you have with respondent Marlene Ramirez?
2.
And what are their names and ages, please?
Diego Velasquez, 6 years old. Isabel Velasquez, 5 years old.
Thank you. Your Honor, at this time, I ask the court to take judicial notice of the order that is on record with this court, the order in suit affecting parent-child relationship that was entered by this court December 26th of 2023. That's the order that we are enforcing today.
Okay, the court takes judicial notice of the order as well as all contents of the court's file.
Thank you. In your order in suit affecting parent-child relationship entered by this court on December 26th of 2023, Mr. Velasquez, what kind of conservatorship were you awarded as to your children, Diego and Isabel?
I have joint conservatorship.
Okay. Who was given the right to designate the children's residence?
Mrs. Marlene Ramirez.
Okay. Were you awarded a possession schedule to see the children?
Yes.
Can you briefly tell the court what your possession schedule was in terms of the Thursdays?
On Thursdays, I have every Thursday of every week from 5 in the afternoon until 7 in the afternoon.
Okay. And is that only during the school year?
Yes.
And in order to exercise your Thursday time, are you ordered to also contact Ms. Ramirez by text that Monday of that week by 5:30?
That's
I'm going to
correct.
object as to leading.
In the order, are you ordered to contact me? Overrule, I'll allow it.
Okay. From the time that this order in suit affecting parent-child relationship was entered in December 26th of 2023 until shortly before the time you filed this lawsuit to enforce your possession time and other conservatorship rights, were you seeing both children according to the possession schedule that you were awarded?
Yes.
Okay. Before you filed this enforcement lawsuit, was there a time that you experienced that either of your children were resistant to returning to their mother, Marlene Ramirez?
I'm going to object as to leading. and to relevance.
Your Honor, the whole point of the enforcement is that the children were not, my client was not given access to the children. And this, what I'm asking my client about goes directly to that. That's what started this whole thing.
Before you filed this enforcement lawsuit, was there a time that you experienced either of your children were resistant to returning to their mother? Sustain this to relevance.
Mr. Velasquez, please briefly respond to that question.
No.
Yes.
You should stay in to relevance.
Oh, I'm sorry. Okay. Let's go to, let's please look at Exhibit B. I'm going to share that on the screen. Your Honor, may I do that?
Yes.
Okay. Let me pull this up. Is everyone able to see this screen?
Yes.
Okay. Mr. Velasquez, on please look at Exhibit D, and what we're looking at is this page here. What is Exhibit D? What is this exhibit about?
It's screenshots of conversations between me and Marlene
Okay.
Ramirez.
Okay. And on Sunday, September 8 of September 8, 2024, as ordered in your order, in your order that's dated December of 2023, can you please, did you advise Miss Marlene Ramirez that you would be exercising your rights to see your kids on that Thursday, September 12th?
That's correct.
Can you please tell the court what day and time on September 8 of 2024 that you texted Marlene to let her know you'd be seeing the kids on Thursday?
On September 8, I sent her the message at 5:32 p.m.
Okay. And were you there at Marlene Ramirez's house on September 12th to see the kids?
Yes.
Were you ordered in your order to do all exchanges at Marlene Ramirez's house?
That's correct.
And what time on September 12th, 2024, according to this screenshot, did you text Marlene Ramirez to let her know you were there to pick up the kids?
4:57 p.m.
Okay. Did you ask for both children?
Yes.
Did you get both children?
No.
Are you asking the court to find that Marlene Ramirez violated the order of December 26, 2023, when she did not surrender your son Diego Velasquez to you on Thursday, September 7, 2024 for your possession time?
Yes.
On Monday, September 16, 2024, did you text Marlene to let her know you'd be exercising your right to have possession of the kids for that Thursday, September 19?
That's correct.
Okay, can you please tell the court what time on Monday, September 16, that you texted Marlene Ramirez to let her know you'd be exercising your right to see the kids on that Thursday, September 16?
At 10:58 in the morning.
Thursday, September 19, 2024, did you arrive at Marlene Ramirez's home to pick up your children?
Yes.
According to this screenshot, what time did you text her to tell her that you were there to pick up the kids?
5:05 p.m.
Did you tell her you wanted to see both kids?
That's correct.
Did she release both children to you?
No.
Are you asking the court to find that Marlene Ramirez violated the order of December 26, 2023, when she did not surrender your son, Diego Velasquez, to you on Thursday, September 19, 2024, as ordered for your possession time?
Yes.
On Monday, September 29, 2024, did you text Marlene to let her know you would be exercising your right to have possession of the kids on Thursday of that week, October 3rd?
That's correct.
So Monday, September 29, 2024, what time did you text Miss Marlene Ramirez to let her know you'd be picking up the kids on Thursday?
At 3:18 p.m.
Okay, on Thursday, October 3rd, 2024, did you arrive at Marlene Ramirez's house to pick up the kids?
That's correct.
And what time did you text her when you arrived that you were there to pick up the kids?
4:45 p.m.
Did you ask for both kids or just one?
Both children.
Okay. I will ask you to look at Exhibit C. One second.
Can you clarify which violation you're looking at? I'm confused. I didn't see, I'm looking at your motion and I
I'm
don't
sorry,
know.
I'm rushing through this because we have very
That's
limited
okay. I'm
time.
sorry. I'm confused. I don't know which violation you are. Could you skip number one?
Sure. I'll go back and do that.
Okay.
So,
Thank you.
the first violation, Thursday, September 12, corresponds with violation number 2 in our
Okay.
motion.
Okay.
And the second violation we just talked about corresponds with violation number 3 in the motion.
Okay.
And this third one, Thursday, October 3rd, corresponds with violation number 5.
Okay. Thank you. Sorry,
Okay.
I was
No,
losing
I
track.
appreciate you asking.
This section locks in repeated Thursday violations. The father followed text notice rules, arrived on time, and asked for both children. Only one was released. That's legally critical. Courts don't weigh excuses here, they weigh compliance. If one child goes and one stays, is that confusion or willful defiance
Very
under oath?
briefly tell the court what this exhibit is.
It's a screenshots of conversations between me and Marlene Ramirez.
Okay. In this conversation, what specifically are you talking about?
I was asking Marlene Ramirez for the children's school information.
Okay. What is the day and time of this, the very first day and time that you asked Marlene for the information regarding the identity of the school that the children attend?
It's July 30th of 2024 at 12:06 p.m.
Has Marlene Ramirez ever provided you with the school identification of the school that the children attend?
No.
Are you able to exercise any of your conservatorship rights as to where the school, what school the children go to, without knowing what school they go to?
No.
Are you asking the court to find that Marlene Ramirez has violated your conservatorship rights as ordered in numbers 1, 2, 5, 6, and 7 of the conservatorship rights section found on page 3 of the order in the suit affecting parent-child relationship?
Yes.
Does this violation correspond with violation number 20 in your first amended motion to enforce possession and access?
¿Escuchó la pregunta, señor? I did not hear the question.
Does this violation correspond with violation number 20 in your first amended motion to enforce possession and access?
Yes.
Thank you. I pass the witness, Your Honor.
Okay, counsel, you have 2 minutes and 53 seconds left.
Thank
Attorney,
you.
Yes, let me. So, Mr. I'm sorry, is it Espinosa? Oh, I'm sorry, Mr. Velasquez, sorry. So today, in your first amended motion for enforcement, you alleged 22 violations of the court's order. Is that correct?
That's correct.
But today, it sounds like you're only proceeding on, I guess, 5 of them.
Objection, Your Honor. We have all of 15 minutes. We don't have time to go through all 22.
I
What's
think it's a
your legal
relevant question. I mean,
what's your legal objection?
Argumentative.
Overruled.
but today you're only proceeding on 1, 2, 3 of or 4 of them. Is that correct? I'm sorry,
Yes.
3 of them. Is that correct?
¿Es eso correcto? That's correct.
Okay. You and Miss Ramirez have. There's been several times since this order was entered that you have and her have not gone by this court order. Is that correct?
No, that's not correct.
Well, let's look at your first amended motion for enforcement. Your first alleged violation, you told the court that you went to pick up your children on Saturday, September 7th, 2024, and not Friday, September 6th, which was your day to pick them up. Is that correct?
That's correct.
Okay. And so, according to the standard possession order that is in your final order, your time of possession is supposed to start on the 1st, 3rd, and 5th Friday of each month at 6 o'clock. Is that correct?
Objection, Your Honor. Relevance.
Your Honor, I'm trying to establish a pattern.
Your Honor, we put forth the violations we put forth were Thursdays, not the weekends.
Okay, 1 second. What are the actual violation numbers that you're proceeding with today?
They are, The first one is violation number 2 in the first amended motion to enforce.
Okay.
The second is violation number 3, and the third is violation number 5.
Okay,
And
so
also we did violation number 20.
okay, so only 2, 3, 5, and 20.
Correct, Your Honor.
Okay, and Attorney Garza, I'm stopping the screen share. There you go.
Okay.
All right, Attorney Harper, you may proceed. So now you know we're only going on 4 of the violations.
I am going to move on. Mr. Velasquez, so on violation number 2, the exhibit that was shared, you allegedly texted Miss Ramirez and told her that you were outside. Is that correct?
What day? I'm sorry. What day was that?
It was September hold on. I think it was Thursday, September 12th is alleged violation 1. He texted her according to the exhibit.
I don't have the evidence on the screen, so.
Oh, okay. Did you text Miss Ramirez to tell her you were there to pick up the kids?
Now the pressure flips. Under questioning, father admits he didn't call police or knock again, but the order never required that. The judge later confirms it. Showing up was enough. Defense tries doubt, but transcripts, timestamps, and selective surrender expose a contradiction that sharply weakens the mother's credibility right here.
Yes, every time that I go pick up the children, I will send Miss Marlene a text message letting her know that I'm outside.
Okay. When you're alleging that she failed to release your son, did you go up to the door? Of the residence of Miss Ramirez?
I went up to a gate where I can access her property.
And did you call her?
I sent her a message.
Okay. Did you make a police report?
On what date specifically?
In violation number 2, you allege this occurred on Thursday, September 12th.
No.
Let's move to alleged violation number 3, which violation number 3 on the motion for enforcement, but it's your second violation alleged today on Thursday, September the 19th. You sent a text message to Miss Ramirez telling her you were there to get the kids, right?
Correct.
Okay. And you're alleging that she did not release the child, Diego Velasquez, to you. Is that correct?
That's correct. She only gave me my daughter, Isabel Velasquez.
I'm going to object as to non-responsive after yes.
Same.
Did you, when you allegedly failed to get possession of Diego, did you call Miss Ramirez?
On that day, September 19th?
Yes.
See.
You did?
No, I didn't call her.
Did you call the police and make a police report?
No.
And then let's move to violation in your motion, number 5. Alleged violation was also on let's see. Yeah, violation number 5 is on a Thursday, October 3rd. Did you text Miss Ramirez to let her know you were there to pick up the children?
Yes, that's correct. I sent her a message to let her know that I was there to pick up the children.
Okay. And so after you allegedly did not get possession of Diego Ramirez, did you call Miss Ramirez? I'm sorry, Diego Velasquez.
No, I didn't call her.
And did you make a police report?
No.
Do you know where your children go to school?
No. As of now, no.
And how old are your children?
Diego Velasquez, 6 years old. Isabel Velasquez, 5 years old.
Your Honor, I'm going to pass the witness at this time.
Right, and counsel, you have 6 minutes and 32 seconds left.
Thank you, Your Honor. Mr. Velasquez, as far as the makeup possession time you're asking for the court, are you asking for possession of both kids for the full Christmas break this year, which is the full 2 weeks instead of one?
Yes, that's correct.
Are you asking the court to award you with possession of both kids for Thanksgiving next year?
That's correct.
Are you asking the court to award you with 60 days this summer, that is summer 2026, with the kids instead of just the 30 you are currently awarded?
That's correct.
Are you asking that the 60 days that summer of 2026 begin at noon on the first Saturday following the day the kids are released for summer break?
Yes.
Would this make up for time that you missed with your son Diego?
Yes.
Is it in the best interest of your children?
Yes, I believe so.
Are you asking the court to order that Marlene Ramirez pay reasonable attorney fees and court costs to you pursuant to Texas Family Code 157.167 subsection B?
Yes.
Your Honor, I do have on file an affidavit in support of attorney's fees. It's in the court's record. I'm asking that the court take judicial notice of that.
I can't take judicial notice of it. It's not a pleading.
Okay, all right.
You can share your screen.
But yes, Your Honor, I can do that. It is. Can everybody see this screen?
Yes.
Mr. Velasquez, do you see on the top right of the screen, the date of May 22, 2025?
Yes, that's correct. Yes, I do see
Okay.
it.
Did I share with you that I filed this affidavit in support of attorney fees for my work on your case?
Yes, you did.
And with this affidavit, did I attach a copy of the, let me see, a copy of the billing records and a copy of my contract to you? Let me get down there. There's the contract.
Counsel, you have
Yes.
15 seconds.
Okay. And is this is for work up to May 21st, 2025, the day before I filed this. Is that correct?
That was your last question.
Yes, that's correct.
Okay. That's my last question. Then I suppose nothing further, Your Honor.
Okay. Attorney Harper?
Yes, so Mr. Velasquez, you are asking for the entire Christmas vacation, Thanksgiving break of 2026, and an extra 30 days for the summer of 2026. Is that correct? Or is that my understanding?
That's correct.
Thank you. Okay, so of the possession violations you're starting today, they were all Thursdays. So there was 3 alleged Thursdays. And if it was correct, that would be 6 hours of total time that you were that you missed. Wouldn't you agree with that?
Objection, Your Honor, that argumentative, I mean, we only had the opportunity to put on just those 3 violations, those 4.
May I respond?
No, I said overrule.
I'm sorry?
I overruled her objection.
Okay, thank you. I'm sorry. So you're asking, Mr. Velasquez, you can go ahead and answer the question, or do you need me to repeat it?
The courtroom pivots toward consequences. Despite arguments minimizing missed hours, the judge focuses on authority of orders, not math. 6 hours lost still equals a violation. Requests for extended makeup time are scrutinized, but contempt hinges on obedience. This moment signals jail is possible and the tone in court turns unmistakably serious.
Yes, can you repeat it, please?
Okay. So, and your attorney, you're asking for an extra 30 days in the summer of 2026, Thanksgiving possession of 2026 of the children, and for 2025, you want the entire Christmas break, right?
That's correct.
And you believe that that's reasonable for allegedly missing 6 hours of possession based on your testimony today. Is that correct?
I haven't seen my son Diego Velasquez ever
I'm
since
gonna object
September
as to
of
non-responsive.
2024.
Thank you. Your Honor, I'll pass the witness.
All right. You may call your next witness. You have 4 minutes and 16 seconds left.
I do, Your Honor.
No, Attorney Harper, you ran out of.
Attorney Harper, I'm sorry. Go ahead.
Your Honor, I don't have any witnesses.
All right. Attorney Harper, does your client work?
Do you mind if she's in the conference room? Can I go ask her?
Yeah. Or can she hear us?
Yeah, she's on there. Okay, I'm sorry. Do you work?
Yes, ma'am.
What are your work hours?
I start at 4 and it just depends on the workload, but it's usually the latest that I've worked is maybe from 4 to 4.
Is that 4 p.m. or 4 a.m.?
4 a.m. to 4 p.m. That's like the latest. And then from that, it varies.
Okay. So what's going to happen is I am going to find you in contempt for violation number 2, and I'm going to place you in jail for a period of 10 days.
Your Honor, I was going to make a oral request for a motion for a directed verdict because he did not meet his burden. If I may put my statement on the record.
You can. Go ahead.
Okay. Thank you. At this time, respondent moves for a directed verdict and denial of the motion for enforcement. Contempt requires proof beyond a reasonable doubt of a clear order of valid possession right on the specific date, ability to comply, and willful disobedience. Move it failed on multiple elements. Specifically, I'm looking at violation number. I think it was 5, alleged violation. she don't even have the right dates in there. If you look at it, she's alleging that my client's possession was on Thursday, October 3rd, and she's further down in that alleged violation, it refers to September the 19th. That's just one of them. First, the evidence shows that several alleged violations occurred on dates that, I'm sorry, I'm going to strike that part. Movement appeared at times outside the SPO exchange window. He did not ever testify as to the address for where my client was, where he was whenever he was denied these alleged periods of possession. He also stated that he did not call her and that he would wait outside. I believe that he has to make an effort to go to the door of Ms. Ramirez. He did not testify that he has done that. There's been no evidence of a willful disobedience beyond a reasonable doubt, which is what the finding has to be in order to put my client in jail or to make a finding of contempt. And so at this time, I'm going to ask the court to deny the motion for enforcement in full and find that the movement did not meet their burden beyond a reasonable doubt to make a finding of contempt and to put my client in jail.
All right, the court grants the motion for judgment on violation number 5. The court still finds her in contempt on violation number 2. Just so we're clear, there is nothing that requires father to do anything additionally beyond him showing up. It does not require him to give mother a second phone call. It does not require him to make a police report. Both of them have copies of the court order, and they both are aware of what their rights and duties are under the court order. And clearly your client knew because he was able to take one child and not the other one. So the court finds her in contempt on violation number 2. The court is going to order that she serves a period of 10 days in jail beginning on tomorrow. She needs to surrender herself to the court by 9 a.m. Attorney Garza, I need you gave me an order, but the order has a lot of language in it from the other violations that's not needed. I only need an order that holds her in contempt for violation number 2, a period of 10 days.
To begin when, Your Honor, tomorrow?
Yes.
Okay.
Which was the exhibit for the attorney's fees?
It's on record. It's not an exhibit. It's on record with the court.
Okay. I don't have an exhibit in front of me for attorney's fees. I only have somewhat of her testimony, but she didn't state a number or anything like that, and I didn't get any testimony from you. So the court can't award attorney's fees based on that. I mean, attorney's fees are statutory according to the law, but I don't have an actual number in front of me. So
I wish I could have had more time, Your Honor. With an interpreter, it's super limited, so I'm sorry.
now what the court can do, that what you did file on record with the court, you can make that an exhibit. You can make that exhibit E because you did file it with the court. It's just not an actual, it wasn't anything for me to take under advisement. But
Right.
I mean, excuse me, not under advisement. It wasn't anything for me to take judicial notice of because it's not an actual pleading. It's
Okay.
an
Understood. Well, then I ask that the court accept that as exhibit E.
yeah, I mean, I have to. The
Okay.
the statutory.
Okay.
I also, in addition to the commitment order, I also need the well, no, I need the commitment order in addition to the order on enforcement.
Okay.
Need both of those right away.
Understood. And do I email those to you directly, or how do I get them to you quickly?
Email directly to my coordinator, Brittany.King@dallascounty.org.
Okay.
So I can't ask for suspended commitment?
You can, but I'm not granting a suspended commitment.
Okay.
Is there anything further for the record?
As far as attorney fees, if we're going by what I do have on file, which is Exhibit E, how much do I put in the order for attorney's fees?
Just leave it blank.
Leave it blank, okay. I believe that's all I have, all I need. And I'll get to work on this immediately, get it to you by the end of the day, Your Honor.
Okay, thank you. Oh, and makeup time. I forgot the makeup time. I am going to award him makeup time on a Thursday. And Attorney Harper is correct. It's 6 hours. So I have to look at the calendar though. So just put the language in there for a Thursday, and then I'll finish writing in what that's going to look like, because I don't want it to coincide with time he would already have.
Right. So it should read that there will be makeup time awarded for a Thursday?
Or just put Thursday and then leave it blank, and I'll put the date and all the rest of the language in there. If you just wanted to put some lines.
Understood.
Yeah.
Okay.
Okay. And, make sure you also add the language in there. And ma'am, I'm ordering you to appear here at 9 a.m. tomorrow morning to the George Allen Courts Building, 600 Commerce Street on the 4th floor, the 255th District Court, not the Associate Court, because they're on the same floor. Dallas, Texas, 75202. You're not to bring anything with you. If you do have to drive, just make sure someone is here to take over your keys, so they'll be able to retrieve your car, so it's not towed for you leaving it here.
Okay.
Okay? Thank you all.
Thank you, Your Honor.
You're welcome. You're excused.
Final ruling lands hard. Contempt on violation 2, 10 days jail, immediate surrender, ordered. No attorney fees awarded, limited makeup time granted. The judge makes it clear, orders require no extra effort, only compliance. Like, comment, subscribe, and share for more shocking courtroom stories where actions meet consequences and excuses fail under law.